Clients will very often come to me and say, I paid a considerable amount of money to my ex-partner in property settlement after separation, and a sizable component of those monies related to the fact that he or she had the custody of the children after the relationship broke down. In fact, my lawyers during the property settlement said if it weren't for the fact children were here, I would be required to pay her or him perhaps say 50% of the matrimonial asset pool. But because there are children and the children have gone and lived with my ex-partner, she has or he has the custody of the children post-separation, that 50% jumped to 75%. So I've paid a massive amount of money for these children. I provisioned for them by way of property settlement, but I'm getting no credit for that at the child support agency. The child support formula does not give me any credit for the fact that I have paid sometimes hundreds of thousands of dollars to the mother or the father because of the fact that children are living with him or her. I consider this unfair. Is there anything I can do about that? And the answer to that question is yes. When a client comes to me and says that, the first thing I look at is the property settlement order itself. Hopefully the property settlement order itself specifically says X dollars extra was paid to the ex-partner because of the fact that he or she has the custody of the children. In that situation, it's relatively simple to take along a copy of the court order to the child support agency and have the child support agency vary the child support assessment because of that. Unfortunately, though, it's not very often the case that the court orders delve down in that level of granular detail into why certain percentages or certain amounts of money were paid to the ex-partner. Often there's just a figure and it's not delineated as to how much of that figure that is to be paid to the ex-partner relates to the children or otherwise. Those cases are a little more complicated, but we can still put in a child support change of assessment application at the child support agency based on section 117 2C2 of the Child Support Assessment Act. That's the Child Support Assessment Act of 1989. Another way of looking at these cases is to look at them through the prism of a set-off. And the argument would be that the amount of child support that I have to pay as assessed by the Child Support Agency each week can be set off against the amount of money that I have already provisioned for the children by way of a generous property settlement. Now, the leading court case on that is a case called British Anzani, a 1980 decision of the English Court of Queen's Bench. The case is reported in the 1980 volume of the Queen's Bench Division Reports and can be found at page 137 of that report for those of you who have a law library. If you do not have a law library, most of the cases and other information I'm going to refer to in this video can be found on the Austlii website. A far easier way of ascertaining what the law is on point than reading the primary case is to have a look at an article I wrote for the Family Law Review several years ago. The article is reported at volume 6 of the Family Law Review. It's called The Doctrine of Set-Off and Child Support. And the article appears at page 122 of volume 6 of the Family Law Review. Well worth a look at for a brief summary of what the law is as regards set-off and child support. Well, if you have any more questions or have any more inquiries as to how big property settlements work in with periodic assessments of child support, have a look at my website, childsupportlawyers.com.au. I'm Simon Bacon. I was a child support lawyer for 35 years, and my website has a wealth of information, childsupportlawyers.com.au.